microphone and let me know, just please interrupt me. Or if you want to put a comment into the chat box, I've got Kane Davies helpfully assisting me today with with all things technology, I hope. So just let me know if there's any technical problems, if you can't hear me, you can't see what I'm sharing, then please do let us know rather than suffer in silence. Okay, so I will make a start because I'm conscious that I've already kept you waiting for a while. This is the second of our 5 in 5 seminars that we're running over the course of the 5-week period. Lorna Rigby presented last week on redundancy, and just so you're aware, coming up we've got collective redundancy coming up next week, so I'm not going to dwell too much on that side of things. We've then got health and safety dismissals, which is obviously particularly pertinent at the minute with everything that's going on, so that's the following week. And then finally we're looking at disability discrimination. So I hope that you find the 5 sessions useful. In terms of today's session, so as I've said, we're looking at changing terms and conditions of employment. If you have a question as we're going along, then probably the best thing to do is to type the word question into the question box. All of your microphones are automatically muted. That's just to prevent interference if you're out and about, or if, like me, you've got children in the background. So they will be muted, but you can put a question into the question box or just type the word question, and we'll unmute your microphone and you can just ask the question. I'm more than happy to take them as we go along, so please interrupt me if there's something that is particularly relevant to that section. Alternatively, I'm going to allow some time at the end for questions, so you can pose your question then. Or if you'd rather not do it on the public forum of today, then please do drop me an email if there's anything that I've not covered or that you want to explore further. I'm available on angela.barnes@napthans.co.uk. As I say, feel free to ask a question if there's something that comes to mind after the session. Okay, so moving on to what we're going to cover today. I'm hoping the session will last probably under an hour, and then allow some time for questions after that. Any more than that, and I think you may be bored to death of talking about changing terms and conditions. Now, just broadly to explain with terms and conditions, they obviously evolve and change quite significantly over the course of an employee's employment, often quite naturally. So it might be a promotion or an annual pay increase, and that in itself is a change to terms and conditions, but one that is very rarely met with any sort of opposition or resistance because they're favourable. So, you know, many employees wouldn't complain about a pay rise or a promotion. Occasionally, you know, you want to change the terms and conditions so that they might be to the detriment to the employee, and that's where it's often a lot more contentious, and that you can then have legal challenge. These broadly fall into 2 categories. So firstly, you might be changing terms and conditions to generally harmonise the conditions for your staff as a whole. So you might want to put all your senior managers on one contract, then your managers on a different one, and then, you know, your general workforce on another one. But you might want consistency across those levels, and that's where you might look to harmonise terms and conditions. The other way is if you want to make very discrete or specific changes to a contract of employment. So you might want to change pay rates or pay structures or contractual bonus schemes, or I guess thinking particularly in relation to coronavirus, you might want to stagger start and finish times so that you're more compliant from a health and safety perspective. So you might want to put half of your staff starting at 9 AM instead of 8 AM, and those sorts of changes. So that's why, you know, it might be you know, more relevant to you at the current times, and that you might want to move it around so that, as I say, you're more compliant from a corona pandemic point of view. Okay, now in terms of the agenda, I'm going to focus more on these specific changes to contract employment that may be met with more resistance. There are various ways that you can change the terms and conditions of employment. One is where, as it says on the slide, the change is already authorised by the contract. So it's drafted sufficiently broadly that whatever you're trying to achieve can be achieved by using the existing terminology that's already there. So we'll look at that firstly, because obviously that's your easy option if you've got sufficient flexibility already. The next three options, going back to kind of old school contract law, you either need to make the change by express agreement. So this is employer saying, we wish to change these terms and conditions of employment, and ideally employees saying, yes, that's fine. You've got agreement from both parties, and that's legally the safest and best option for you. Failing that, you've got unilateral variations, which is where the employer is saying you will, these changes will come into force without the agreement of the employee. That option is fraught with difficulty, really, and whilst we'll go through it as an option, it's not one that I would normally advocate. So we'll look at the legal dangers around unilateral variations. We'll then move on to dismissal and re-engagement, which is the one that you quite often use if you're left with no other option. So maybe you've tried express agreement, the employees haven't agreed. What do you do? And you may be forced to dismiss their current contract of employment and re-engage them on new terms. And I'll talk you through how you would manage that sort of process. And then finally, to close, I'll look at a couple of ad hoc points to cover off before we then move on to questions. Okay, I'll keep things moving along, but as I say, do interrupt if there's something that you'd like me to expand into further. Okay, so let's firstly look at the changes that are authorised by the existing contract. So employment contracts are no exception to the general rule of contract law that a contract can only be amended either in accordance with its terms or with the agreement of all the parties. So here we're focusing on in accordance with its terms. So the question to ask ourselves at the outset of any change in terms and conditions scenario is, does the existing contract already allow for the proposed change? And if it does, brilliant. You don't need to go into a more formal process. And the three questions there that I've posed: is the clause already wide enough to accommodate the change? So it may be possible to interpret the existing terms sufficiently broadly to accommodate the change, and we're going to look at examples of this in a moment. Secondly, is there a specific flexibility clause where the employer has an express right to make a change in relation to a specific term? And then finally, is there a general flexibility clause? So this is where at the end of a contract of employment, it may say, we reserve the right to vary the terms of your employment in any way. You will look at that and whether or not that can be relied upon, and if so, in what situations. Now, there are limitations with all three options, so we'll look at them in a bit more detail. So firstly, interpreting the existing terms. So this is where you can interpret the existing terms sufficiently broadly that it means that you can achieve whatever you want to achieve. So this is most commonly seen with job titles and job descriptions. So as you may be aware, it's a legal requirement to have in your written terms a brief description of the job description, a brief description of the job title or a job description. And it's sensible from my perspective and as an employer's perspective to keep this quite broad so that you don't run the risk of the employee saying that's not within my job title or that's not within my job description, as I'm sure you may have heard in the past. So we tend to go fairly broad with these. So it may say something like, you may be required to undertake other duties from time to time as we may reasonably require. And that's so that hopefully, if you want to slightly tweak or vary the terms of the job description or job title, you can do so relying on that particular clause. Now, there's definitely a balance to be struck here, because if you go too narrow, then obviously there's a risk, as I've said, of the employee saying that's not in my job description, I don't have to do that. But if you go too far the other way and go too broad, then if challenged at an employment tribunal or in the courts, then an employee may say that there's ambiguity and it was never clear what my job description was meant to be. And generally, tribunals tend to side with the employee if there is any question of ambiguity there. So, in terms of my advice here, be careful when you're drafting job titles and job descriptions. I think quite often we do it without thinking too much, but really do apply your mind to what you need to get out of that employee, and what is, more importantly, what is reasonable to expect them to do. And as I've said, the employer must act reasonably. So if you're, for example, employing an accountant, is it reasonable to ask them to clean the toilets? Probably not. But there's obviously examples that are much closer than that, and you need to, when applying any such clause like that, act reasonably. So is it reasonable to ask them to do it? Have you given them an explanation as to why they need to do it, especially at the moment where we maybe are asking employees to go a bit further than is necessarily in their job title? And also, have we given them plenty of notice so that they've got time to adjust to the change in their job title? So you can sometimes rely on interpreting in the existing terms, but as with anything, a degree of caution, and where we really see it is in terms of job titles and job descriptions. Moving on, in terms of specific flexibility clauses, and the best example that I can give of these is a mobility clause. So that is where in your contract of employment, employee's contract of employment, it will say you are required to work at our Preston factory, or such other place within 25 miles, for example, as we may reasonably determine. So it's where within the existing contract, you've got that flexibility to move the employee, to relocate the employee if you need to. So it's for that example where maybe you're building a new site that's 5 miles down the road. You don't want the contract to completely preclude a move in terms of place of work, to then mean that you have to negotiate amended terms just to move them 5 miles down the road. So it's important to try and build in a degree of flexibility. If, for example, you have multiple sites, then you may want to give yourself that flexibility to move them, maybe 25 miles to a different site, either for a temporary or a permanent period. So a mobility clause will give you that level of flexibility. And do be careful again, employment tribunals give a very narrow interpretation. So they will, if there's ambiguity, favour the employee in this situation. Also, be minded of the specific facts to your scenario. So, for example, a few years ago now, I had an example where a client wanted to move an employee from working at Cockermouth in Cumbria to Whitehaven, and that's about a 13-mile distance. And the employee took the employer to tribunal and said that although there was an existing mobility clause, that was beyond reasonable, and that it wasn't appropriate or lawful to make him change his place of work in that way. Now, we won that case, and part of that was because it was only a 13-mile distance, and in that part of the world, it's he had a car, he could quite easily drive. Be careful if you're in inner city London and you're requiring someone to work 25 miles away. That may be a commute of 2 hours or more to get from their normal place of work to a different place of work. So be mindful that you need to think about, think it through, and bear in mind that it's very fact specific, and you may need to have a flexible approach in that regard. As I've said there, employees need to act reasonably and, as a minimum, explain the reason for the change. So what's the business rationale? Very rarely do businesses just want to do it on a whim. There's normally a financial consideration or a logistical consideration. If you explain that to the employee, it hopefully means that they are far more accepting of the change. As I said, give reasonable notice. So again, there's no legal minimum that you need to give, but give them enough notice that they can come round to the fact of a move. And again, that may mean that they agree and accept the change far more willingly. But also consider offering financial assistance. So if there is going to be a slightly longer commute, you might want to think about, for a set period of time, helping them towards the cost of that commute. So specific flexibility clauses can be helpful, but as with anything, there's only so far that you can take them. If you needed to go beyond what is reasonable, then you would need to look at one of the other 3 options that we'll talk about in due course. Then thirdly, we'd look at general flexibility clauses. So this is where employment contracts may try to give the employer a general right to make changes to any term of the contract. So this is where at the end of the contract, you'll see a clause, we reserve the right to make reasonable changes to any of your terms of employment. And I've had a number of clients over the years who've said to me, you know, this means that we can change the contract because we've got that right to do so. And obviously, if only it were true, that you know, the contract of employment is primarily there to protect the employee, and it wouldn't make sense that the employer could change any term that they wanted just because they had a clause at the end of the contract stating that. So again, it's got to be exercised with a very significant degree of caution. I've said there, they are rarely enforced in practice by the courts and tribunals, and really this sort of clause is only there to capture minor and administrative changes to the contract. Just to bring out a couple of tribunal claims there that give us guidance on this. So with the Banham case, as I said, unlikely that employer will be able to rely on such clauses to the employee's detriment. So crucially, if there's a detriment there, it's very unlikely that you could rely on one of these general clauses. And in this case, the employer, Philips Electrical, sought to remove healthcare, so to take away that support. And not surprisingly, the tribunal said, no, you cannot rely on a general flexibility clause to remove that benefit for the employee. In the Norman case, it was very similar, but this was about sick pay provision. So they wanted to remove an element of contractual sick pay entitlement. And again, they couldn't rely on that. And the way I would think of it is the sorts of change that you could make under these clauses is if the contract named a specific healthcare provider, but you want, so it was Bupa, for example, but you wanted to use a different provider, then you could change the provider in the contract, providing that the terms were no less favourable, there was no disadvantage to the employee, and they were getting the same benefit. So as I've said, it's really just from an administrative perspective that you could rely on a general flexibility clause. Okay, so what if the change is not authorised by the contract, which is going to be a large proportion of your proposed changes to terms of employment? As I said earlier, there are three options. One is seeking the employee's express agreement to the new terms, either on an individual basis or on a collective agreement, which would be binding on the employees. I'm not going to dwell too much on that, but that's another way in which express agreement can be sought. The second way is unilaterally imposing the change and relying on the employee's conduct to assume that they've accepted that. Again, because there is uncertainty there, it's not an ideal choice. Finally, terminating the employee's employment and offering re-employment on new terms. It's high risk. There's unfair dismissal claims potentially, and multiple ones if you are changing a number of employees' terms and conditions of employment, but at least you have the certainty of knowing whether or not they agree to the new terms. So I'm going to go through each of these in more detail. So express agreement, it's an effective way to vary a contract of employment, and from a legal and practical perspective, it's the best option because they are voluntary entering into that amended agreement on new terms with the employer. And to be honest, this would normally be your first step in any change in terms and conditions scenario. So you wouldn't move to unilateral variation or termination of employment, dismissal and re-engagement unless you firstly considered seeking their consent. It goes without saying. As I said there, the consent that they give must be voluntary and free from duress. So that again goes back to normal principles of contract law. Holding a shotgun to their head and telling them to agree the new terms isn't going to work. Equally, telling them that they'll never get a promotion in the rest of their career, that's not free from duress. So you need to be careful with that balance of incentivizing them to accept, which we'll talk about, but not forcing them to accept the change. As I said, their verbal agreement is sufficient. So there have been case law on this point as to whether or not it has to be in writing. It doesn't, but obviously, as with anything, it's far better that a written agreement is obtained, because otherwise an employee can later contest whether or not verbal agreement was sought and obtained, and it may leave you open to risk of claims if you don't have a written document confirming that. But as I've said, their written agreement doesn't always take precedence over what has been agreed verbally, and this was the case in Simmons and Doughty Seals, where the claimant won his case because he could demonstrate that although the written contract says he would work night shifts, it had been verbally agreed with his employer that he would work day shifts instead of night shifts, and he challenged them on the point. They forced him to work the night shifts, and he took them to tribunal, claimed constructive unfair dismissal, and he won. And that just shows that yes, verbal can take precedence over what is there in writing, but most importantly, make sure that your written agreement reflects what is happening in practice, because you don't want the ongoing risk of liability of the question of what has been agreed verbally rather than in writing. Now, express agreement, and again, back to basic principles of contract law, you need consideration. So for any agreement to be varied, it must be supported by consideration, meaning that there must be some benefit passing from one way and the other way in order to get a legally binding agreement. Now, I said there, what benefit has passed to the employee in consideration for a change made to their contract? Now, employment law is in quite a unusual position in this regard, because you could have an argument that the very simple fact that they continue in employment and they are continuing to be paid is sufficient consideration for the change, which obviously in normal contract principles you wouldn't necessarily have that ongoing argument. So as I say, that in itself may well be, and I've said there, is continued employment sufficient? It can be, but be very careful, because what if the change that you have agreed doesn't take effect until much later in the future? So for example, you may well have changed the restrictive covenants or a notice period, and that wouldn't take place, the actual change itself wouldn't take place until the end of the employee's employment. So would the consideration question link that you were giving them at this point in time with a change that will happen much later in time? In those sorts of scenarios, it's much better to apply specific consideration and to make it very clear that that is what you are doing. So if in return they are getting a pay rise, for example, so quite often, if someone gets a promotion, they will need to enter into restrictive covenants because they're in a more senior position and more risk to the business if they leave, then you would be right to say, well, you are getting a pay rise, and that is the consideration then for the extra duties that you are having to enter into, or extra obligations. So as I said, just be mindful if the change takes effect in the future, but if it's something immediate like a pay rise or change in hours of work, then the continued employment should be sufficient consideration in that respect. A few practical tips for express agreement, and I'm currently going through one of these with a client at the moment, and this is where the softer side of HR, and by that I mean not to be soft, but the more delicate skills of really a negotiation, because the employer in this situation is undertaking a selling exercise. Let's be honest, they want the employee to easily accept the change because it's for the better good of the company, and that's far better than going down any dismissal and re-engagement route or unilateral variation. So I've said that the way in which employers approach the task of changing terms and conditions and persuading employees is important, and really shouldn't be underestimated. Keep in mind the following points. So why is the change needed, and have you explained that to the staff? So especially at the moment, we've had various changes to terms and conditions over the last few months, and quite often a change may be the lesser of two evils, because if the employee doesn't accept the amended terms, then redundancy may be an alternative. So does the employee know that? Do they know the position of the business and why it's so important that the terms and conditions are changed? Do all of the changes have to be implemented at one time? So, you know, is there any way of phasing the changes if there's multiple changes, or staggering them in some way so that the employee doesn't feel that they've been bombarded with a number of changes all at once? Again, it's the practical side of things. Can the employees be offered an incentive to help them accept the change? Yes, absolutely. Sometimes they can be given a financial incentive, but also, you know, try and think outside of the box with these things. So, you know, whether it's, I don't know, free lunch or whatever, but, you know, I think sometimes we think it's just a financial incentive that they would accept, but maybe it's a give and take exercise of giving them some more favourable terms in another respect and taking away on the other hand. So that's one to think about. Listen to what the employees have to say, and you know, with any exercise like this, one of the main complaints that employees have is that they're not being listened to. So you try to listen and understand where they're coming from. Perhaps they've got a better solution to this situation rather than changing the terms and conditions. So listen to what they've got to say, and also, is the timing of the change right? So you know, especially at the moment, businesses are you know, a lot of businesses are really struggling, and you may have no option but to make the changes now. But on the other hand, some businesses are able to wait. So, for example, they could make a change to terms and conditions coincide with an annual pay review, which then may make the employee more likely to accept the change because they are getting something in return, in essence. So those are just things to think about when seeking express agreement, and some practical tips to help the employee understand why the change is necessary. So what happens if you are seeking express agreement but the employee doesn't give it? Can you rely on an implied agreement to the change? As with anything, it's certainly not preferable. We'd rather have express agreement. But what happens in that situation? Now, it may be that they are deemed to have accepted the change. So if they don't make it clear that they're working under protest, and we'll look at that in more detail. So, you know, employees should really be saying, you know, I'm not agreeing to this and I'll carry on working under protest. But if they don't and they start working to the new terms, then there's definitely an argument there that the employer can say that they deemed to accept the change, but it's just not an ideal situation. Does the change have immediate practical effect? Because if it does and they carry on working, then, so for example, if it's a reduction in pay or a change in working hours or role, and the employee continues to work without clear objection, then that's a much stronger argument to say that they've impliedly accepted the change. If the employee has impliedly accepted the change, can they still bring a claim for constructive unfair dismissal? And no, they can't. If they haven't made their disagreement clear, then no, they wouldn't be able to still bring their claim for constructive unfair dismissal. But as I've said, it's much better if you can to get their express agreement to the change rather than seeking to rely on just their implied conduct. Okay, so as I've said, express agreement is the best way to change terms and conditions of employment. But what are the options if you can't get express agreement? As I said, unilateral imposition of the change is the second option, and that would be a breach of the contract of employment. So straight away, you're up against it in terms of the employment law surrounding this. How can the employee respond? So they can accept the breach by carrying on working under the new terms. So as I've said, they don't object and it's just kind of seamless. They carry on working, and that is the ideal situation for the employer, but it's difficult because, again, you know, at a later point in time, the employee may say that actually, no, I am objecting to this, and you just haven't got that certainty of a clear offer and acceptance as you have with express agreement. They could work under the new terms under protest, and we're going to look at that in due course. You know, they would then have claims for potentially breach of contract, or lawful deductions from wages. It's known as standing and suing. We'll look at that in more detail. They could resign and bring a claim for constructive dismissal, constructive unfair dismissal, which again, a significant risk. They could refuse to work under the new terms, so they could carry on working to the old terms. Obviously, there's certain things that they couldn't really do. So if it was a reduction in wages, they couldn't carry on working under the new terms. But you know, for certain things that they could, you know, say for example, they could still start coming in at 9 o'clock instead of 8 o'clock, and try and just stick to their original terms of employment. They could work under the new contract and claim to have been unfairly dismissed from the old contract. So that would be a way of mitigating their loss, but they'd still have a potential claim for unfair dismissal under the old contract. Okay, so I said we'd just have a quick look at working under protest. This is where it gets really quite difficult with unilateral variations. So this is where an employee works under the new terms but makes it clear they do not accept the change. As I said previously, it's known as standing and suing. So this is where, for example, if you'd reduced their wages, then they would carry on working, but then they'd sue for the difference in the pay. So it's you know, it's an ongoing liability, as I've said, a continued liability for the employer, and it's that degree of uncertainty that makes it very difficult. What form must the employees protest take? They just need to make it clear that they're not accepting the new terms. They can't carry on and then a year later say that they're not accepting, but as long as they've made it clear. But also the acceptance or the protest doesn't have to be immediate, so they could say, I'll give it a try, I'll do it for a trial period, or, you know, if they've done it for 3 weeks and then say, actually, this definitely isn't going to work, I'm making it clear that I'm protesting to this change, you know, that then would be working under protest, and that, again, there would be that ongoing risk of liability. Okay, and what are the remedies? And again, this is where it's particularly difficult for unilateral variations. So potential claim for breach of contract. Now, notably with unilateral variation, because the employment is continuing, the breach of contract claim would have to be brought in the civil court rather than the employment tribunal, because breach of contract claims can only be brought in the employment tribunal. They only have jurisdiction to hear breach of contract claims when it's upon termination of employment. So it's more difficult for the employee because they'd have to go through the civil route. So they tend not to be as keen to go and sue for breach of contract. Instead, they may bring a claim for unlawful deductions from wages, the difference in pay, because they can bring that claim much more easily in the employment tribunal. There's also a risk of unfair dismissal claim, as I said, from the old contract of employment, and also constructive unfair dismissal. So if the employer imposes the change in the terms of employment, they may choose to resign and bring a claim for constructive unfair dismissal, but they have to show that the change amounts to a repudiatory breach of contract. So that, by that I mean a significant change to their terms and conditions of employment. But as you'll see, you know, that's a long list of claims potentially whilst they're still working, which in itself, you know, if you're being sued by a current employee, it's always more tricky, I think, to manage internally rather than an employee who has left employment. So for many reasons, unilateral variation is not a very attractive choice for employers. By far more common in this situation of changing terms and conditions is ending up in a position of dismissal and re-engagement, and it is very much a last resort. So you know, as I've said, express agreement is always something to consider first, but you know, to have that degree of certainty, dismissal and re-engagement at least gives you that, but obviously a risk of unfair dismissal claims as well. So this is where employers terminate the existing contract and offer employment on the new contractual terms. So it would happen seamlessly in the sense that the notice would expire on the old contract, and the following day they would be given the new contract of employment. So continuity would be preserved if they then accepted the new terms, and they would then work under the new terms. But as I say, you've got that clear line in the sand that that ends the old contract and starts the new one. So when thinking about dismissal and re-engagement, again, it's very much selling exercises, selling the re-engagement, but also think about, is collective consultation necessary? Because this is potentially a redundancy situation, and that's something that you'd need to think about at the outset. And so obviously, If you're talking about sufficient numbers, so 20 plus in a 90-day period, then a collective consultation may be necessary. I'll not dwell on that too much because it is going to be covered off in the next session. But as I say, don't assume just because it's a dismissal and re-engagement that collective consultation redundancy obligations wouldn't arise, because they may well do. Also think about, has correct notice been served? So I think quite often in dismissal and re-engagement situations, we focus very much on the consultation part of it, but make sure you're not exposing yourself to a wrongful dismissal claim where you simply not served the requisite notice under the contract of employment to end the first contract before beginning the second. So it seems like a basic point, but make sure that correct notice has been served. Now, as with any situation like this, you need a good business reason for making the decision to dismiss, and to have followed a fair process to defend the potential unfair dismissal claims. And I'm just going to go into that in a bit more detail now. So, as I've said, it could be a potential redundancy situation, but we also tend to, and probably more so than redundancy, we tend to focus on this as some other substantial reason, an SOSR dismissal. So just going back to the basics of employment law, you've got 5 fair reasons for dismissal. So conduct, capability, illegality, some other substantial reason, and redundancy. So there you go, 5 reasons. If we were to defend proceedings, so unfair dismissal claim on dismissal and re-engagement, then we would probably argue both points, so that it's a SOSR dismissal but also a redundancy, if the circumstances were such that it was a redundancy situation. So what do you need for your fair reason for SOSR? You must have a sound business reason for dismissing an employee who refuses to accept the change to their terms and conditions. I'm going to look at this on the next slide in more detail, but this isn't the tribunal saying that they think it's a sound business reason. This is about the reasonable employer. And so, you know, they're sort of stepping into the employer's shoes and deciding, you know, what is a sound business reason for making this change. You then need to follow a proper procedure. So dismissal, and if you're going to dismiss, you need to consult with the employees over the proposed change, meaningful consultation. And the question that sometimes get asked is, does the Aircast code apply? So it applies to it applies to dismissal, disciplinary and grievances, when I get my teeth put back in, but it doesn't apply to SOSR dismissals or redundancy. But to be honest, you know, there's no harm in following the Aircast code and guide as general principles, because you need to have a fair procedure. And you know, I guess the point to bear in mind is that the claimant at the end of the day couldn't claim that there has been a breach of the code and guide if they were bringing a tribunal claim eventually, but it's best practice to roughly follow the code and guide, even in a redundancy and SOSR dismissal anyway. Okay, so how do you evidence a sound business reason in SOSR dismissal? As I've said, it's a question of what the employer considers a sound business reason, not what the tribunal considers a sound business reason. So it's not their own assessment. They can't come in afterwards and say, we would have done it differently, or we would have, you know, we don't think that's you know, a fair business reason. It's very much what the employer did at that time. And notably, the change doesn't have to be crucial to the survival of the business. So it may be a money-making exercise, or sorry, money-saving exercise that's a necessity, but it doesn't have to be crucial to the survival of the business. I mean, at the moment, it may well be anyway. But the tribunals, it's not such an extreme test that, you know, without making these changes, the business could go bust. Employer must be able to produce evidence of the business reason for the change, and this is crucial. So, as with any litigation in the employment tribunal, tribunal judges want to see contemporaneous notes as, you know, why was that decision made, and where is the evidence to support that, and that's crucial in any case like this. Otherwise, inferences could be drawn, and you know, they may conclude that actually there wasn't a sound business reason simply because it's not documented as such. Okay. So if you are looking at dismissing and re-engaging, what factors would a tribunal, and indeed what factors should you be taking into account in changing terms and conditions? And consider these as a whole. So just because you maybe fall down on one of them doesn't mean that it would be unfair. But look at the business motive. So as I said, you need a good business case to show that the change is required. Look at the employee's reasons for rejecting. So have you listened to what they've said? And if so, why are they saying that they won't accept the new terms? And that should be taken into account. Were the employees given reasonable warning of the change? That again, tribunals will look at that in assessing how the employer has behaved in this situation. Has a sufficient explanation been given to the employees? And again, this is all part of the meaningful consultation, but do they understand? As I've said, if redundancy is the alternative, then has that been explained to them, that really the employer feels that they have no alternative but to change terms and conditions in this situation? Think about impact assessment, and by that I mean, have you thought about how the change will impact upon the employees as a group, but also individually, to see what, is this going to be, severely to their detriment? And if so, that's a more fundamental change, and one that would be scrutinised more closely by an employment tribunal. Have alternatives been considered? So these may be raised by the employees as part of the process, that they suggest alternatives, or they may be alternatives that you've come up with yourself as a business. Have they been considered and fully explored? Was voluntary agreement sought? So as I've said, express agreement, if you can, in any process like this, you would try and get their agreement first. And this is why, because it's one of the factors in determining whether or not the dismissal was reasonable. Have there been reasonable and genuine consultation process, which I've already mentioned? Have you listened to the employees and responded reasonably? So taken on board their comments and given an outcome if, for example, if it's not going to work, if their suggestion isn't going to make the difference between whether or not the changes are necessary or not. Crucially, have the majority accepted the change? So if, for example, this is 100 employees who you're changing the terms and conditions, and maybe 80 of them have accepted the change by express agreement, that can be compelling to an employment tribunal that actually they are quite reasonable, because otherwise why would 80% of people have signed up? And as I say, it's not fundamental, as in it's not the only factor that a tribunal would take into account, but it is one factor that they will certainly look at. Equally, the view of the trade union. So just because a trade union are against the proposal doesn't mean that the dismissal wouldn't be reasonable, but it is one factor that they would look at in deciding or determining that issue. And as I've said, consider the reasonableness as a whole, not one of these points in isolation, but all together. And that is broadly what a tribunal will consider in looking at employers' decision to dismiss and re-engage. So what if the employee doesn't sign the new terms and you're potentially faced with a number of unfair dismissal claims? And the burden is very much on the employer to show an unequivocal act implying acceptance. So obviously in any dismissal and re-engagement situation, you would want a clear written express agreement to the new terms. And very much the burden is on the employer in that respect. So you wouldn't want to simply dismiss and then make any assumptions about what they're going to do after that point. So express agreement in writing to the new terms should be sought, in very clear terms. Now, question: if the employee doesn't agree to the new terms and they've been dismissed, then there is an argument that you can run in the employment tribunal as an employer that they have failed to mitigate their loss. So they had, on a plate, they had re-engagement on different terms, and a tribunal will look at, well, how reasonable would it have been for the employee to accept those terms? And again, that comes down to questions as to, what is the detriment the employee would suffer in entering into those new terms compared to walking away and potentially being unemployed. So it's a balancing act, but there's certainly an argument that we would run that the employee has failed to mitigate their loss because they haven't agreed to the new terms. And I'm getting very close to the end of my session now, but just finally to close us off with some other considerations and just things to think about more generally. So as I've said there, even if the change is permitted under the contract, the change may not be lawful. So this is where an employee and employer agree a change, and that's fine, but there is some other overriding law, so whether it's statutory, piece of statute, that means that change isn't permitted. So for example, if there's a clause in there that seeks to remove an employee's protection rights, and this is where we're talking about section 203 here of the Employment Rights Act, that wouldn't be permitted because you cannot agree to remove employees' protection rights. So for example, the fact that they have unfair dismissal claims after 2 years of service. So that's one aspect. Another is what's called a penalty clause. So you could agree in a contract with an employee that there will be, for example, we see this with repayment of study fees. If that clause is not dealt with in a reasonable way, so for example a sliding scale or some sort of an element of reasonableness, then that clause, even though it is agreed between employer and employee, that wouldn't be lawful. So if in terms of repayment of training fees, we normally do it on a sliding scale, so that if they leave within a year, maybe they have to pay 100% of the training fees back, but if they leave within 3 years, it would be unreasonable to expect them to pay 100% back. So you've got to be reasonable in how you apply that. If you're not, then it wouldn't be lawful. The other thing to be mindful of is the Equality Act, so it always sneaks in there somewhere. Do be mindful if you're changing terms and conditions that, especially with indirect discrimination, there may be a potential risk there. So we talked earlier about mobility clauses, and do be careful, because if you're moving sites, for example, and you're seeking to relocate employees, it may be that women are more disadvantaged than men in that situation because maybe they have more childcare responsibilities, and so there may be an argument for indirect discrimination there that you would then have to justify. So it's just something, I know it's difficult because it's one of those ones that you maybe won't know it's a risk until it's realised, but try and think broadly in terms of how is this impacting upon each individual, and are we being fair and reasonable in imposing this change. And finally, section 4 statement. I think I maybe mentioned earlier that certain written terms have to be given to an employee now from day one. That's section 1 of the Employment Rights Act. So things like job description, place of work, salary, they have to be given from day one. If you are changing terms, then there is a section 4 statement which says that you have to declare those changes to the employee within a month of the change. Now, 9 times out of 10 that would be covered off. So in a dismissal and re-engagement situation, you are offering new terms which would probably take you beyond the requirements of section 4, quite honestly. But again, if you're dealing with a unilateral variation, again, the risk is there that you don't comply with section 4 because you don't actually declare to them what their changes are. So it's just something to be mindful of. It's quite often a technicality, but you wouldn't want to overlook it then, because there is a potential claim that they could tag along there. Okay, it's been quite a whistle-stop tour. I've got plenty of time for questions. As I say, if you want to put a question in the question box, or if you want to follow up with me afterwards, that's fine. Kane, have we got any questions? Or
no, we've not got any questions yet. Does anybody have anything they'd like to ask?
I'll give it a couple of minutes and then just see if anyone wants to ask anything. as I said, just to recap, whilst I've got all of your attention, we have got 3 more sessions in this series. So collective redundancy, I think it's next Wednesday, and then following that we've got health and safety dismissals, and followed by disability discrimination as the final session. So if those are of interest to you, it'd be really good to see you on those sessions as well. Any questions, Kane, or are we quiet on the questions?
We've just got one from Terry and just said, are we able to get copies of the slides, please? Yes, Terry, these will be sent round tomorrow, also with a recording of this webinar as well. So that'll be sent to everybody's emails tomorrow. But I think that's it. I think that's all the questions.
Lovely. Well, as I say, it's angela.barnes@nepthons.co.uk. If anyone wants to ask me a follow-up question, I appreciate there's quite a lot to take on board, and also changing terms and conditions, you know, very fact specific and can get really quite complicated. So if anyone wants to follow up with me afterwards, I'd be delighted to speak with you. Just let me know. Okay. Well, thank you all very much for your time. Thank you, Kane, for helping with the technology. I would not have managed without you. Yeah, as I say, I hope you're available to all join in the next session. Thank you. Bye.